Oh shit, Preston, you have a book. Pity you didn't actually read it. I love the genius of Preston Poulter's stupidity because it's a thing of special magnificence. He freely admits that the sole purpose for him trying to trademark the phrase Comicsgate is to stop Ethan Van Sciver from using the phrase to promote and sell comics, a phrase which Ethan doesn't actually own and has been used by hundreds of people to promote and sell their artwork as well. Nevertheless, Preston Poulter wants to trademark the phrase to troll Ethan Van Sciver specifically and keep other people from using it. That's actually what he's doing. Keep in mind, Preston didn't create the phrase Comicsgate. He wasn't the first to use it online to promote any artwork, and he wasn't the first to use it to sell comics. By that measure, he has no legal right to the phrase. By virtue of it already being in use, he's simply trying to take away what belongs to someone else. Now, both Preston and his gaggle of sycophants think they've made people butthurt over this. Yes, you have. From laughing our asses off. The only thing dumber than this would be a grown man arguing on the street with another man over a $40 comic book, or butting up with a known right-wing extremist and then wondering why no one wants to work with him, or nuking his YouTube account after he got made fun of by two fat guys in masks. I'm actually enjoying this, because to me, this is the equivalent of a homophobe trying to trademark the word queer so he can stop gay people he hates from calling themselves queer, so he can call them queer instead. As moronic as that is, Preston, you realize they can just use a different word. Oh fuck, they're calling themselves queers. What do you want to do? I'm gonna buy it. Now what you gonna say? We're gay. Problem solved. And not only would it be solved, but the new word wouldn't have any of the negative connotations the previous one did. So all you've done is given them a clean slate. But you've got another problem, Preston. Other people have already used the phrase Comicsgate to sell and promote comics. And as you explained in your recent video, if someone were to create a unique comedic skit as an intro to their video and you copied it, that could constitute infringement. Couple of points though. The example you gave isn't the best example, and the reason why is because an introduction is too common. Radio shows, movies, TV shows, and video games feature various introductions with so many iterations that there's bound to be similarities, so it'd be difficult to call that trademark infringement, especially since you can't trademark songs, film, or dialogue. That's a copyright, baby. He's got the book. Look, he's got the trademark book with that smug grin on his face. He read it all by himself, so now he's a legal expert on trademark law, which he immediately gets wrong. On your first try. On your first try, all prepared with your lynching face, and you still got it wrong. Then he goes on to explain how a person could steal someone's trademark the person knows someone else is using by basically hinging on this argument that if the person sees Preston's intro and tells him, hey, that's my thing, you can't use that, but the person doesn't immediately file a cease and desist order, that the intro is now in the public domain, so anyone can use it. And of course, he just claims this is so, rather than open up the book he flails around and quote the text supporting his claims. But unlike Preston, I have no problem with providing evidence for my statements. From ConeLG.com, quote, a commonly misunderstood feature of trademark law is that not only do trademark owners have the right to enforce their trademarks, they have an obligation to enforce their trademark rights. If a trademark owner does not satisfy his affirmative obligation to police and enforce his trademark rights, the trademark may, after widespread unauthorized use, lose its distinctiveness and therefore its status as a source identifier or trademark. This is what Preston appears to be talking about. However, in his scenario, the person explicitly states, this belongs to me, you can't use it, which is as clear a cease and desist complaint as possible short of an actual cease and desist order. This is why it's so important to know what you're talking about. Don't wave a book around like owning a book makes you an expert. You're just cherry picking information and not quoting it. So unless someone bothers to check, and I'm sure none of the people snickering along with you will do that, no one will know whether you're lying, misrepresenting the law, or telling the truth. I, on the other hand, will check, and it appears you're doing a lot of misrepresenting and lying. For example, the response cannot be immediate because first a person must determine whether there is infringement. From the same source as before, quote, the two initial and indeed main factors that will be considered to evaluate scope and severity of infringement are the sufficiency of similarity between your trademark and the offending trademark and the sufficiency of similarity between the goods/services you sell and the goods/services sold under the offending trademark. In other words, Someone could use the same phrase, but use it to sell tables while the other business sells guitars, and there would be no violation. It gets trickier with logo design. In general, as long as they don't look similar, it probably isn't infringement. Obviously, the more recognized the logo, the harder it will be to get around that. For example, if you had a company called Dog Catcher and used the letters D and C in a circle as your logo, it's possible that this may be too similar to DC Comics' logo and be considered a violation. All of this falls under whether or not there will be confusion for customers. Quote, this sufficiency of similarity standard, either vis-a-vis the marks themselves or the goods/services, falls under the likelihood of confusion legal doctrine, which is used to determine if trademark infringement has occurred. Simply, would a customer who views this new trademark come to believe that the source of this new trademark is the owner of the original trademark? And that leads us back to Preston's attempt to trademark a phrase being used by other people in commerce, because that is specifically what he's doing. He's attempting to prevent Ethan Van Sciver from using Comicsgate to sell and promote comics, which Ethan has already done. Oh shit. Preston, Pumpkin, that means that by your own admission, you're engaging in trademark infringement. Allow me to explain. Ethan didn't create or spread the phrase Comicsgate. He wasn't even the first to create comics using it. However, it has become associated with him and his comics. From a legal perspective, if no one else shows that they used the phrase to sell comics or related art before that, Ethan could claim that he has an unregistered trademark for Comicsgate. And no, he does not have to state no one else can use this. That's not a functional requirement for trademarks or copyrights, which your little book should have told you. This is how people who create paintings and music and videos and movies and put them online or share them abroad can claim copyright infringement should anyone pirate their work, even though they never registered the art with the United States Patent and Trademark Office. The purpose for registering copyrights, trademarks, and patents is to have stronger protection and a stronger defense in cases of violation. It's not a requisite. I don't have to tell you that you're not allowed to use my artwork without my permission. No matter how smug your face gets, that I haven't explicitly told you no doesn't give you the legal right to use it. The same applies to trademarks. This information should be in your little book. So if you were to publish any comics using Comicsgate, you would be in violation of Ethan's unregistered trademark. Now, there is some wiggle room due to this happening online. However, there's another problem. You're aware he's been using it, as is verified again by the smug expression on your face every time you talk about it. And no, I didn't pause to try to get that expression. Literally every time I pause the video, this is what you look like. If Ethan told you to stop, specifically told you that you can't use it to sell comics, if that has occurred at all, you're effectively infringing on the trademark. The next step would be a formal cease and desist letter from Ethan to you. But there's another problem, Preston. See, in your infinite wisdom, you file for a trademark on a phrase you admit is already in use by another person selling comics. So when you filed your trademark, if you failed to mention this, that could be considered potential fraud against the United States Patent and Trademark Office. Why? According to ConeLG.com, there's the issue of the likelihood of confusion. Would someone confuse your usage of Comicsgate to sell comics with other people's usage of Comicsgate to sell comics? It would boil down to these factors: similarity of marks, strength of mark, similar of goods and or services, commonality of trade channels, sophistication of marketplace and consumers, whether or not mark was used in bad faith, evidence of actual consumer confusion. And thanks to you and your gaggle of chucklefucks, all of those have been fulfilled. In fact, that appears to be the point of you doing this, to specifically confuse people while also trolling anyone who already used the phrase. Now you may be thinking, aha, you stupid jigaboo, I filed a trademark, so there's nothing anyone can do. That would be wrong too. From Justia.com, quote, being the first person to file an application to register a trademark does not guarantee that you will get priority over the trademark. Instead, the date on which the mark was first used determines the right of priority to the mark. This means that you can get trademark rights limited by territory even if you are a tiny, lesser-known business with an unregistered trademark. However, the filing date of a registration is considered constructive use of a mark, and it gives priority over a later date of actual common law use in commerce if the registration application results in a registration. In other words, if someone can prove that they used Comicsgate in commerce before you did, and plenty of people can prove that, you don't get to own the trademark. But there's a larger problem, Preston, which your big brain somehow managed to miss. You can't trademark common phrases. This is the reason why Ethan couldn't claim he owned the copyright or trademark, and why people got upset when he did. Comicsgate is a term used by thousands of people to describe a particular group of people. Thanks to the silliness of the internet and the number of people who oppose and support the group, it's not just used as a noun for that specific group, but also used as an adjective, specifically a pejorative, to describe a type of person who, incidentally, looks a lot like you and likes to wear smug expressions and wave things around, though usually not books, mostly tiki torches. Because Comicsgate is effectively a common phrase, you can't trademark it. Remember when LeBron James tried to act like a smug douche too and trademark Taco Tuesday? Turns out he couldn't do that, and that was because of this common phrase or widely used message provision. From the TMEP statute 1202, section 4, subsection B, quote, widely used messages include slogans, terms, and phrases used by various parties to convey ordinary or familiar concepts or sentiments, as well as social, political, religious, or similar informational messages that are in common use or otherwise generally understood. The more commonly a term or phrase is used in everyday speech or in associational or affinitive manner by various sources, the less likely consumers will perceive that matter as a trademark or service mark for any goods or services. The example given in the statute is that of "I love you" appearing on bracelets. No one can own that phrase because it's seen as a term of endearment, not a source identifying mark. Moving on, messages that merely convey ordinary familiar concepts or sentiments that are used by a variety of sources in the marketplace are considered commonplace and will be understood as conveying the ordinary concept or sentiment normally associated with them, rather than serving any source indicating function. Another example of this is "I heart" or "love" DC, "driving safely," and "think green." These can't be trademarked. And I can hear you, Preston. Comicsgate isn't a common phrase. It's associated with the movement. I hate the movement. Well, according to the statute, quote, messages that are used by a variety of sources to convey social, political, religious, or similar sentiments or ideas are likely to be perceived as an expression of support for, or affiliation or affinity with, the ideas embodied in the message, rather than as a mark that indicates a single source of goods or services. Furthermore, goods that feature such messages are typically purchased because of expressive sentiment conveyed by the message, and not because they serve as a means for the consumer to identify and distinguish the applicant's goods or services from those of others. For example, the proposed mark "Once a Marine, Always a Marine" for clothing was found not to function as a mark because the evidence showed that it is a common motto used by and in support of the U.S. Marines. Similarly, the proposed mark "No More Rhinos" for various goods including bumper stickers, signs, and t-shirts was found not to function as a mark because the evidence showed that consumers were accustomed to seeing this well-known political slogan on these types of goods from a variety of different sources. Comicsgate is used by one group of people as a group marker and slogan, while other people use it as a pejorative. Either way, thousands of people have used it to such an extent that it has become a widely used message, not unlike Gamergate. You would not be allowed to register the trademark under this statute. Oh, and it gets worse, Preston. Quote, any evidence demonstrating that the public would perceive the wording merely as conveying the ordinary meaning of the message, or enthusiasm for, affinity with, or endorsement of the message supports this refusal. In addition to dictionary or encyclopedia entries showing the meaning or significance of wording, supporting evidence may include materials, e.g. websites, internet search result list if sufficient surrounding text is included, social media pages, product fact sheets, and other promotional materials showing the applicant's manner of use and the manner of use by third parties. So when you file for the trademark, Preston, did you include that third-party information, letting the USPTO know of the frequency of use of Comicsgate on social media, promotional materials, and news media over the last 3 years? Did you report that other people use the phrase to promote and sell the very product you're trying to sell, comic books? Because if you didn't, if you hid that information from the USPTO, that could qualify as fraud. Understand, I don't give a fuck about the name Comicsgate, you or your drama with Ethan Van Sciver. If y'all want to act like a bunch of children, that's fine by me. I'm not involved, and I'm pretty sure that if there's shit to be had, neither of you are clean. I'm also not attached to any label. I review and comment on comics. Your little troll has nothing to do with me outside of me letting other people know what you're doing. However, I do give a fuck about somebody making a complete ass of himself by potentially opening himself up to a civil suit for trademark infringement and potential fraud. Here's the deal, Preston. If you want to beat Ethan, make more money on a comic than him. That's all you gotta do. Steal away his audience if you have the charisma to do it. I mean, you've already got some of his sloppy seconds groping at you, so have at it. Beat him at his own game. But trying to beat him by trademarking what's effectively an insult to most people who hear it looks stupid. You can try to spin it as much as you want, but this is as dumb as someone trying to trademark MRA or male tears or Preston Poulter. The only one who looks foolish is you. Ethan will put out another book and get $500,000. Short of him pissing off all the people who support him, he's gonna continue to sell comics. You lose. If he actually sues you, he's got 2.5 years of evidence showing him using Comicsgate to promote and sell his and other people's comics. You lose. Antonio Malpica has stated that he intends to pursue to keep his trademark that he filed several years ago. If he gets that, you lose. Even if none of that happens, the phrase has been used by so many people that it's effectively a common phrase, so you don't have any legal right to it. You lose. And so do all the people who used Comicsgate before Ethan arrived. See, in your infinite wisdom, you didn't think about that. The idea that all these people who feel that they're part of a movement will now have to deal with yet another Johnny-come-lately hijacking their thing. All those people who built their channels, all those people who made comics, all those people who designed a Comicsgate mascot, you're stealing their thing away from them to troll someone many of them don't even like. Now, I don't imagine that they're going to rise up en masse to stop you, but that doesn't make it any less douchier to try to take something that doesn't belong to you. This is why I told people not to get attached to a label in the first place, and not to treat Ethan like a de facto leader. You're handing things over to him, so when he does something you don't like and you want it back, you probably ain't getting it back. But still, that doesn't mean it's alright for someone like you to take something that's theirs. I'd be making the exact same video if someone pulled this shit with feminists or Christians or progressives. It's not theirs, and chances are the people trying to buy them don't want to be associated with the phrases anyway, so leave them alone. You're trying to beat Ethan Van Sciver, and you think you can do it by taking away his symbol. But Comicsgate was never his symbol. His symbol is something else, and he already owns it. But have at it, Preston. Whether you succeed or fail, you've only made a fool of yourself and all the lemmings who back you. But what do I know? I'm just some guy.